Who controls Washington's wallet? The Supreme Court and the biggest fiscal cases of the last century. Some of the most important Washington State Supreme Court decisions have not involved criminal law or free speech or search and seizure. They've involved money, taxes, spending, and who gets to decide how public funds are collected and used. At first glance, these three cases seem unrelated. A capital gains tax, $30 car tabs, school funding, but beneath the surface, they all raise the same constitutional question. Who controls Washington's wallet? The legislature, the people, or the courts? I'm Kareem Merchant, and I'd be honored to serve as your next Supreme Court Justice. These videos are about constitutional law, civics, and how government is supposed to work. They're for educational purposes only and should not be interpreted as a promise about how I would rule in a future case. With that in mind, let's get after it. The Constitution starts with the people. Washington's Constitution creates multiple centers of power. The legislature possesses the power to tax and appropriate funds. The governor administers government. The judiciary interprets the Constitution. And uniquely, the people themselves possess the power to pass and reject laws through initiative and referendum. That means major financial decisions can originate from multiple directions, sometimes from the legislatures, sometimes from voters, sometimes from constitutional rulings. The result is an ongoing constitutional conversation about who gets to make financial decisions for the state. The seminal income tax case. When it comes to taxes in constitutional law, we must start any legal analysis with the 93-year-old income tax case, Culliton versus Chase from 1932, not 3 years removed from the start of the stock market crash of 1929. The people of Washington, in the most democratic way possible, came together by way of constitutional initiative and resolved to enact a comprehensive tax reform package. The people passed two initiatives simultaneously on the 1932 ballot. The first initiative passed created a progressive income tax. The second initiative was a tax reduction in real estate taxes. The measures weren't intended to change the amount of tax revenue generated. Rather, it was designed to equitably shift the sources of tax revenue in response to what we now know as the Great Depression. The court concluded that income tax constituted property under Article 7 of the Washington Constitution and thus cannot be progressive and must be capped at 1% annually. While the decision rightfully struck down the progressive income tax as unconstitutional, the companion tax relief measure was wrongfully enacted into law since the income tax was supposed to offset the tax relief. Instead, the result is less tax revenue on real estate and zero revenue from the progressive income tax. And that meant schools and government programs missed out on millions upon millions of very necessary tax dollars during the worst economic time in our nation's history. I don't think that the voters would have passed the tax relief initiative if they had known that the progressive income tax measure would fail. Whether one agrees with the decision or not, its significance is undeniable. That one case from 1932 shaped Washington tax law for generations. The Culliton case had enormous influence over fiscal policy. But in the last 14 years, we've seen a tremendous shift in the way the Supreme Court decides tax cases and the effect it has on the state's wallet. Let's start in 2026 and work our way backwards. In the last legislative session, the legislature passed a state income tax of 9.9% on income exceeding $1 million. Last month in May, our state Supreme Court, led by Chief Justice Deborah Stevens, reserved ruling on the constitutionality of the state income tax, but struck down the people's attempt to invalidate the income tax law through referendum. They did that based on the legislature's necessity clause, thus stripping the people of the power to reject laws passed by the legislature. From the 2026 state income tax, we move to the capital gains tax of 2022. 9 decades after Culliton decided that income was property, the issue returned in a different form. Our Washington State Supreme Court reviewed the constitutionality of the capital gains tax in Quinn versus Washington State. Our Supreme Court was tasked with determining whether capital gains are considered property under Amendment 14 of our state constitution. If it's property, then it can't be progressive and it can't exceed 1% annually. But if it's an excise tax, then the legislature can tax that shirt to the moon. The Washington State Supreme Court ultimately upheld the constitutionality of the capital gains tax. Writing for the 7-2 majority, Chief Justice Deborah Stevens concluded that the capital gains tax was an excise tax and not property for constitutional purposes. Justice Gordon MacLeod for the dissent Court argued that capital gains are income and income is property. Therefore, the capital gains tax is a tax on property, and it must be uniformly taxed at 1% annually. As a result of this Supreme Court decision, Washington now has a capital gains tax. Once again, the court found itself at the center of a major fiscal question, resulting in more tax revenue for the government. The next fiscal dispute takes us back to 2020, where the fight came not from Olympia, but from the people themselves. Washington voters approved Initiative 976, a measure designed to substantially reduce car tabs to just $30. The initiative passed at the poll with the 53% majority, but then, of course, the litigation began. The Supreme Court handed down a unanimous 8-0 decision led by Justice Stephen Gonzalez and signed off by the Chief Justice, Deborah Stevens. The Supreme Court invalidated the $30 car tab initiative under the single subject rule, which prohibits a bill from being stuffed with multiple unrelated topics. While the measure arguably contained multiple subjects, the court gave less scrutiny to the car tabs case than any other statute, declining to apply the traditional reasonable doubt standard, which has been precedent since long before the Culliton case from 1932. Equally troubling is the fact that the decision doesn't address a very fundamental issue to the legal analysis: whether the single subject rule should even apply to voter-approved initiatives. It's right there in the language. But our Supreme Court didn't even bother to go conduct the analysis. From my perspective, as a citizen, a taxpayer, and a lawyer in Washington state, it was devastating for me to learn that not one of the 9 justices considered what is to be, for all intents and purposes, a very obvious question of constitutional law. Regardless of one's position, the practical effect of the ruling was clear. This decision saved the government billions in tax revenue. Imagine if you only had to pay $30 for car tabs. How much money would you save every year? Think about the number of cars on the road. Now think about how much the government would lose in that tax revenue. Car tabs would have shrunk by 90%, and that would have crippled government programs like Sound Transit. So to recap, in 2026, no referendum on state income tax. In 2022, the court upheld the capital gains tax, and in 2020, they struck down the People's $30 car tab initiative. Now let's go back to 2012 to witness another historic tax decision, McCleary versus Washington. In that case, authored by the Chief Justice Deborah Stevens, the Supreme Court approached fiscal policy from an entirely different direction. The issue wasn't taxation. The issue was constitutional spending obligations. In a 7-2 opinion, Chief Justice Stevens authored a 78-page decision explaining why the state failed to satisfy its constitutional duty to make ample provision for public school education. Many observers, including critics of the later proceedings, agreed that the court correctly identified a constitutional violation. The controversy, however, arose from what happened next. Rather than simply issuing its decision, the Supreme Court retained jurisdiction, something they never do. They required the legislature to produce progress reports, review legislative responses, and repeatedly evaluated whether funding levels were sufficient. The Supreme Court essentially became the legislature's probation officer. And at one point, our Supreme Court held the legislature in contempt and imposed sanctions of $100,000 per day until they came back with more funding. If you're wondering if there's a separation of powers issue here, you're not alone. In 2014, Justice James Johnson, in a dissenting order, stated, "Such unwarranted extension of judicial authority violates both the constitutional separation of powers and the explicit delegation of definitions and funding for education to the legislature." Meanwhile, the legislature, while on probation with the Supreme Court, increased education funding substantially. State K-12 funding grew from approximately $13.4 billion in 2011 to 2013 to more than $22 billion by the 2017 to 2019 biennium, eventually exceeding $26 billion by 2020. In practical terms, education funding nearly doubled during the 6-year McCleary era. Common theme. Now let's bring it back forward. From 2012 to 2018, the Supreme Court retained jurisdiction over the legislature for the first time in history, resulting in a near doubling of the education budget. In 2020, the Supreme Court strikes down the voter-approved car tabs on questionable constitutional grounds. And then in 2022, the Supreme Court upholds the capital gains tax, calling it an excise tax as opposed to an income tax. These cases involve different constitutional provisions, different legal theories, different outcomes, but they all point toward the same fundamental question: gets to make Washington's biggest financial decisions? The legislature claims authority through its power to tax and appropriate. The people claim authority through initiatives and referendums. The courts claim authority through constitutional interpretation. Each institution possesses a legitimate constitutional role. The challenge arises, however, when those roles collide. The separation of powers question. The most important debate is not whether taxes should be higher or lower, whether education spending should increase or decrease. The most important debate concerns institutional power. What role should courts play when disputes involve billions of taxpayer dollars? Should courts defer to the legislature? Defer to the people when they pass voter-approved initiatives? Should courts aggressively enforce constitutional limitations regardless of fiscal consequences? There are no easy answers because every answer involves competing constitutional values: democracy, judicial review, legislative authority, direct popular sovereignty. Most people think that constitutional law is about free speech or criminal procedure or individual rights, but some of the most consequential constitutional decisions involve money. Who collects it, who spends it, who controls it, and who gets the final word when government institutions disagree? That debate has shaped Washington for nearly a century, and there's no reason to believe it will end anytime soon, because beneath every budget dispute lies a constitutional question: who controls Washington's wallet? I'm Kareem Merchant, and I'd be honored to serve as your next Supreme Court Justice.